The order will begin with Michael Vonn, who's the Policy Director of the BC Civil Liberties Association. Michael Vonn will discuss the broader issues of SLAPP lawsuits and look at a particular example.
Nice to be here. So let me reiterate that SLAPPs are strategic lawsuits against public participation. That is, when big resources, a person or group with wealth, power, and legal resources brings a frivolous or dubious lawsuit against little resources, generally the citizens who have been criticizing big resources, in order to shut down those critics, of course, and intimidate others from doing so. The merits of the lawsuit are absolutely unimportant. The lawsuit can be completely ridiculous and yet achieve its ends. Defending a lawsuit brought by a very powerful litigant is enormously costly in time, money, and emotional resources. A survey conducted by the Canadian Lawyers magazine recently reported that the going rate in Canada for a 2-day civil trial is $25,000, 220 and change. It is therefore not an exaggeration to say that a threat of such a lawsuit can rise to the level of threatening one's very own well-being. And their consequences for democratic process are, of course, equally dire. So, here's the subject of my talk, the 2 big points. We urgently need laws that protect against SLAPPs. And while we're at it, let us reform the laws of defamation. Let me unpack those a little bit. Governments. SLAPPs have long been a tool of corporate intimidation, but just recently we've seen a little spat of governments trying to get in on the action. In 2005, for example, Donald Page, a retired engineer and civil servant, was sued for defamation by the Ontario Township of Montague for making a complaint against the local fire department to the Ontario Fire Marshal. Yes, putting the wax out of your ears, that's right, you heard that. Sued for defamation for a complaint to the fire marshal about, among other things, inadequate training of the volunteer fire department. Once more, complaining about a fire safety issue to the organization statutorily mandated to receive complaints about fire safety issues. The notion is so patently outrageous that it is almost funny. It's not quite the parrot sketch, but we are definitely veering into Monty Python territory when that can be the grounds for a defamation claim. You will, of course, heave a huge sigh of relief to know that Mr. Page was not successfully prosecuted for this in the town of Montague's claim for $50,000 in damages against him. But what did it cost Mr. Page in real terms to defend himself against this suit? And do the citizens of Montague now think twice, 3 times, or 4 times before they speak out about issues of public importance? We certainly know that the legal precedence of that case was not enough to prevent the city of Powell River from trying their hand at exactly the same thing. Last year, the city of Powell River threatened to sue some local citizens for defamation over statements that they had made concerning the utilization of public funds, election proceedings, and conflict of interest. It really is hard to conceive of a libel chill that is chillier or more corrosive of democratic principles than a government suing citizens for criticizing the government. On our association's reading of the relevant case law, and that includes the Donald Page case, we say there can be no legitimate action for defamation on the part of any government of Canada. And we wrote to the city of Powell River to say so, and to share some of the pithier judicial pronouncements on the subject. One of my personal favorites is from Mr. Justice Corbett in the Halton Hills case. I'm quoting from him. When a government is criticized, its recourse is to the public domain, not the courts. The government may not imprison or fine or sue those who criticize it. The government may respond. This is fundamental. Litigation is a form of force, and the government must not silence its critics by force." Unquote. litigation is a form of force. So if a illegitimate lawsuit is threatened by the government to silence its critics, is there any remedy? Yes. There is a possibility that the citizens so threatened might bring an action in constitutional tort. We have recent case law that affirms that damages can be awarded for charter breaches. But this is, of course, all surgery to try to repair the bodies after the train wreck, right? What we need is an ability to prevent the train wrecks from happening in the first place. This is a hugely urgent need. Various examples of SLAPPs are going to be vetted here today. We may have some discussion about some others, but I'm just going to use one example that is very, very timely, and that's the Esen case. You may have heard about this on the CBC. It got a lot of uptake in the media. Jack Esen is a retired Justice of the Peace. He and his wife Judy live in Vernon, BC, in an area of Vernon where water and sewer services are provided by a private utility. Many residents had complaints about this private utility, but only a very few spoke out. The owner of the private utility was very free in threats of lawsuits against his critics. As cited in a letter from a strata plan to the Land and Water Regulatory Body, there is considerable fear in this community over the power of this utility. Individual property owners are fearful of voicing their concerns or objections out of a fear of retribution, which typically involves considerable legal costs. In fact, the owner of the private utility did end up suing Jack and various others for defamation. For, among other things, letters of complaints to the regulatory body and petitions. So again, echoes of the Donald Page scenario, which is of course bad enough. But we don't actually get into full-on Kafka land with this until we get this piece of the story. The utility owner sent a private detective to the Esen's house to misrepresent himself as a prospective buyer of property interested in moving into the neighborhood. So he was sent to get Jack to say something against the utility owner and to secretly record that conversation. That was one of the grounds of defamation that was brought. Now, at trial, the Esens successfully defended themselves on every charge of defamation, much to their credit. And the utility owner appealed. And at the BC Court of Appeal, they, in their wisdom, upheld the lower court findings in all regards with the exception of the piece I've just told you. They did find that there was defamation in the surreptitiously recorded conversation of a private detective who had been invited in on the basis of fraudulent misrepresentation, so on my reading was trespassing, to set Jack up to make comments on the private utilities and its owner by pretending that he was moving into the area. So one more time in slow motion. Jack is successfully sued for defamation for a statement he makes in his own living room to a person who is purporting to be a prospective neighbor. I wish I were making that up, but I'm not. I happen to know the Esens who contacted our association, and that they are very highly motivated to see that nothing like this happens to anyone ever again. Which of course begs the question, what can be done? Well, sadly, the obvious place to begin looks none too promising. In his comments on this story, the Attorney General of British Columbia insisted that courts are already well equipped to deal with vexatious litigation, and that he did not see any need for statutory protections against SLAPPs. On what possible basis he could have come to such a conclusion, we do not know. What precisely is this effective mechanism, and why did it fail the Esens and everybody else so very badly? We do know that the AG's stance on this entirely echoes the reasons why his government gave for repealing the previous government's legislative protections against SLAPPs. Because you see, to add insult to injury, we had such a law. For a very brief time, we had a statute called the Protection of Public Participation Act. And it was the product of extensive debate and consultation, our organization among other groups. And the current government killed it as soon as it could, in the dead of summer. And the AG of that day also argued exactly as the AG of present does, that it really isn't needed, procedural rules are in place that will dismiss frivolous lawsuits. What the AG then and now fail to add on to that is that a review of these rules and the case law that applies to them will show clearly that they are of virtually no assistance to any defendant in a SLAPP suit. Of course we need anti-SLAPP laws. The evidence is mounting up all around us. Many other jurisdictions have seen this and met the needs, and you know there is something seriously amiss in this province when states like Texas and Utah are way ahead of us on this one. It's not exactly bastions of liberal idealism. Anti-SLAPP laws try to prevent SLAPPs by presenting some disincentives to dissuade parties from bringing SLAPPs in the first place. And they also try to sort out, at a very preliminary stage, legitimate claims from illegitimate claims, and to minimize the financial burden on defendants. So, for example, a SLAPP law can, if a defendant can show that their speech, which is in question in this defamation suit, falls within a certain protected category of communications, the onus then shifts to the plaintiff to prove that the lawsuit is brought legitimately. That's one example of what a provision in an anti-SLAPP law could look like. And if the question of the lawsuit's legitimacy cannot be determined at a very early stage in the proceedings, then there could be another provision where the judge has the flexibility to advance or in-term costs to the defendant who would otherwise not be in a financial position to defend themselves. So these are just examples of what anti-SLAPP legislation could look like. And I say, I'm not inventing these. This is what our anti-SLAPP legislation did look like. While we're at it, as I say, the defamation laws seriously need to be overhauled. They are unintelligible to the average person. I'm going to make it. They're unintelligible to the average person. They are currently unintelligible, I suggest, to the average lawyer. The BCCLA is not alone in calling for reformation of reforms to defamation laws. We say that the laws must take as their starting point freedom of expression, and that the categories of qualified privilege and fair comment should be greatly expanded to reflect that necessary starting point. Damages could be reduced to nominal levels, except where the income of the plaintiff has been impacted and that can be demonstrated. So we're looking at actual damages, not the reputation damages that are kind of the standard in defamation laws. And these, as I say, are just examples of reforms that have long been called for. All kinds of things could be done if there were the political will to do them. And there are many speakers who are going to discuss this. So let me just end by making an observation that I don't think has been made in this realm before. As I noted previously, it is the legal opinion of our association that the government is prohibited from suing its citizens for criticism. And not only would such a suit fail, but the citizen might have recourse to charter damages. One of the trickier aspects of constitutional law currently is trying to keep our eye on this moving target of what is government? What is government now? Privatization mania on the part of many governments has made the question of what is government a $64 question in many charter challenges. Attempted SLAPPs by government are mercifully rare, but I'm going to suggest that I happen to know more than one SLAPP in this province that has been brought by a corporation that provides outsourced or privatized services that used to be clearly government. We know that anti-SLAPP laws that were repealed by the government were supported by a broad range of civil libertarian, environmental groups, Union of BC Municipalities, etc. I think we might make certain educated surmises about what and whose interests the government was choosing to protect in repealing those SLAPP protections. To recall the words of Mr. Justice Corbett, litigation is a form of force. If the government is precluded from using such force, the private sector most certainly is not in the current state. And I think that the need to protect citizens who are speaking out in the public forum is even more urgent in light of the shifting sands of what constitutes government for the purposes of charter protection. Those are my prepared comments. Thank you.